Welcome to this month's edition of Stevens Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Good afternoon and happy May 15th, 2022. And more importantly, welcome to episode 21 of Stevens and Stevens Monthly Family Law CLE.
We're finally legal. We can drink.
21.
21.
Time to have some fun.
21 CLEs. How many people do that in 2 years? Come on. And it all goes to a great cause. So I'm proud to have that distinguished fact. And before we talk about our cases, we had a little interesting debate in the office. We made the interesting decision to call our law firm Stevens with a PH and Stevens with a V. And Caryn and I have been kind of tossing around the merits of which name is more lawyerly, I guess. And I'm glad to announce that we have finally arbitrated that. And I'm quite pleased with the result. So without
more lawyerly, how about spelled correctly? Come on.
We all have different criteria. So I don't want to I've said too much. Let me just bring in George III from the Ann Peggy production of Hamilton. King George, tell us what you think.
Hello, it's King George III. And I've been told there's a dilemma between Stephens, PH, and Stevens, V. Well, in my world, there is no dilemma. Stephens, PH, is the right one. That's right, it's more royal, more aristocratic, more lawyerly. Stephens, PH. That's the way I'd go. And you know I'm never wrong. Because I'm a king.
Thank you, King George the Third. Caryn could not agree with you more, right, Caryn?
Oh, definitely. Nothing I love to do but debate with royalty.
So we have some cases to talk about, and we will also have a cool interview that we will keep as a surprise until the end. We have a living legend. Well, it's Roberta Stanley. She's awesome. So we get to have a little professionalism this time, and it wasn't a huge month, just 20 cases this month, March 2022, and the first one was the Moore v. Moore case, which is an appellate land. And this was kind of an interesting case because it dealt with someone trying to get out of being garnished with their wages, and the debtor claimed a head of family exemption. And the case kind of talks about the elements that when you make that claim, it is the individual, whether the individual is head of household is a question of fact to be resolved in each case. An appellate court must presume the trial court's decision is correct unless it shows that there are some abuse of discretions. In this case, there was no transcript. So again, with the many, I don't think there's more group of cases in the past 5 years in our family law that talk about something more than the lack of a transcript in an appeal. So unless the error is on the face of the judgment, it's always going to be reversed.
I feel like these family law cases have been single-handedly keeping court reporters in business. So get a transcript. Our next section is the alimony cases, and we have 3 cases this month in alimony. The first one is White versus White, which is a 4th District Court case out of St. Lucie County. I have personal affinity for this case because I was Mrs. White's trial counsel in this case. And these folks had been married for 11 years, 362 days. So they were married February 4th. Husband filed a petition for divorce on February 1st, 3 days shy of their 12th anniversary. And at the trial court level, the wife was awarded durational alimony. and for 12 years. So the court made a finding in the final judgment that because the marriage was just shy of 3 days, the trial court rounded up and provided Miss White with durational alimony for the full 12 years. And the former husband appealed this trial court order. I was not part of the appellate process here, but when he appealed it, the appellate court said that the statute is clear, it's unambiguous, that the durational alimony awards cannot exceed the length of the marriage. So even it being 3 days shy, 2 days shy, 1 day shy of a particular full year of marriage, you have to strictly construe the statute, and the statute saying that it cannot exceed the length of the marriage. It was not unambiguous what it meant. And so the court did not have the unfettered discretion to round up, so to speak, and provide Mrs. White with 12 full years versus 11 full years, even though the folks had made it for that 362 days. She didn't hit the 365. So this was reversed on the length of the alimony award and remanded back to the trial judge to determine, rather just, cut the alimony short down a year. So that is what White teaches us this month.
That takes us to case number 3 in your materials, the second alimony case, Fabrizio v. Fabrizio out of the 2nd District. And this case, former wife appealed an amended final judgment that dissolves the parties' marriage, mainly on the award of permanent alimony that the trial judge awarded her. In the trial, the trial judge awarded her $1 of nominal alimony or permanent alimony a year. And the former wife appealed, saying that the final judgment essentially didn't include any of those statutory required findings that we all need when judges make alimony awards. The only thing that the final judgment referenced was based on the equitable distribution the wife was receiving along with their financial circumstances, we hereby award the wife $1 in nominal alimony. Under the law, this is not allowed because the trial judge did not make those statutory findings of, does the wife have a need? Does the husband have the ability to pay alimony? And it didn't go into the other factors, or at least talk on the transcript about the facts that would warrant a nominal permanent alimony award. So for that reason, they reversed that portion of the amended final judgment for the trial court to rehear, if necessary, to rehear the evidence to address the issue of alimony.
And then we have the Ogle case, and Ogle dealt with 2 issues in alimony. One was the total lack of the court from making appropriate findings that would help an appellate court decide. No findings of really need or income. And the court awarded bridge the gap alimony so the wife could obtain training that she needs to enter the workforce. And that's just not the purpose of bridge the gap alimony. Bridge the gap is supposed to be to assist a party from the transition of being married to single with legitimate, identifiable short-term needs. In this case, there was no evidence whatsoever of those identifiable short-term needs. It just looks like the court used short-term instead of rehabilitative. So the whole matter was just remanded back to the trial court to fix with appropriate findings, and we'll see what happens with round 2. That takes us to case number 5. Now we're in child support land in Seath v. Seath. You'll also see that under our case 18. It makes another appearance. But for the child support portion, court made a couple of mistakes. They didn't use the proper overnights in the child support calculation. The pro rata share of income on collateral children expenses was wrong. Court failed to enter an IWO, which is required by statute. So whenever there's an error in the overnights, I've never seen it not be reversed. So that seems to be low-hanging fruit. So these errors seem to be easily corrected on appeal. That's the Seath case.
We're going to hop over to enforcement, and our first case under enforcement is the Bentrim case out of the 4th District, and this is a Palm Beach County case. And this case had a quote in it, which I thoroughly enjoyed, and it said, "This case represents another chapter in a long-running saga of post-dissolution proceedings by these parties in both the lower and the appellate court." So I'm assuming if you look at the Bentrim case, there is a multitude of docket entries. These were your litigious former spouses who had been back and forth. They were originally divorced in 2009, and the underlying motion that caused this appeal was an order that got entered in 2020. So some 11 years later, they were still litigating and mass rate against each other, filing various motions. But what this appeal emanated from is the April 2020 order. The court entered an order that required the minor child to go to counseling. And in that order, it required that the parties agree on a counselor, which I'm sure was difficult enough for Mr. and Mrs. Bertram. But more importantly, it said that once they agreed to a counselor, whenever that did occur, that the child and the therapist should have their conversations be protected and privileged pursuant to Florida statutes under the psychotherapist patient privilege. And so they somehow amazingly litigated, fought, and figured out who this counselor was going to be, which was a social worker. And the child went to the social worker. And all of the conversations between child and counselor / social worker were privileged. But mom decided she didn't like social worker and fired social worker. And when she fired the social worker, she also did a request for copies of all the notes from the sessions that the child had had with the social worker. And the social worker, who was unaware of this April 2020 order and perhaps, some part of Florida statutes, went ahead and sent these notes to both parents based on all her sessions she had with the minor child. And the former husband flipped out and filed a motion for contempt and said that the former wife had violated this confidentiality privilege that was contained in the April order. But the problem with the April order is it simply said that all communications for the child with the therapist were confidential pursuant to Florida statutes. It in no way said that parents couldn't get notes, documents, testing, and things like that. So because the order, going back to the old clear and precise language that we probably have 8,000 cases on, the order wasn't clear and precise saying that records were exempt from that or testing results or things like that. It just talked about communications. And because of that, the order that the court entered finding mom in contempt was reversed because it wasn't clear and precise so as to tell mom she couldn't do what she did. We could all dispute that was sort of a roundabout way to figure out what happened in the session, but it was not a violation of the order. So this was reversed.
2189. 2,189 docket entries.
Woo!
The Bentrim matter. And this was the 4th time it went to the 4th DCA. So I could see the appellate court's frustration.
They're like, these people again.
2,000 docket entries. That's a big number.
I very rarely see that. I liked that quote in the case. So more power to the Bentrims.
That takes us to the second case of enforcement, Langestmo v. Metza out of the 4th DCA. This is a post-judgment matter where the former husband filed a motion for contempt or enforcement against the former wife. He was seeking enforcement of a provision in a postnuptial agreement. And in the postnuptial agreement, the former wife was required to pay the former husband $250,000 and an additional $5,000 within 7 days of them executing the agreement. So it was very clear on the date that she was to make the payment. 1 day after its due date, the former wife only paid him about $56,000 of the $250,000. 7 or 9 months later, she gave him another $175,000, which left him still shy or short of $25,000 owed from the postnup. So then the former husband, he proceeded with filing a motion for contempt and enforcement on the remaining $25,000. The magistrate's ruling did grant the former husband his motion to enforce the payment, so he was to receive the $25,000. But the issue here is that the magistrate only granted the former husband the interest rate of what was owed on the $25,000 from the day he filed the motion for enforcement instead of the time frame of when the 250 was due. So the former husband filed exceptions saying the magistrate erred in denying him the statutory interest rate. It was denied, which is what he appealed. And what the appellate court had said here is we agree and we affirm on everything else except for the interest rate, because under the Florida statute where we talk about interest rate, is the courts apply the statutory judgment from the date of loss or entitlement for them to calculate this rate. So what the magistrate should have done here is they should have began to calculate the interest from when the debt was due, which would have been the day after the 250, and not when he filed his motion for enforcement. So therefore, it was affirmed in part and reversed only as for the statutory interest. This takes us to the final case of enforcement, case number 8, Equitable v. Equitable. I don't know if I said that correctly, out of the 3rd district. This is another post-judgment matter here. The parties divorced in 2008. They had an MSA. They had one child at the time, where the father was to pay the mother $800 a month in child support. However, after they got divorced, they had another child. So there's 2 children. One is technically only of the marriage, but MSA, it has a provision, like a lot of us, I'm sure, put in our agreements, that this agreement remains in effect even if the parties reconcile or cohabitate. So short after they got divorced, they of course reconciled. They had another child. The former wife eventually moved back into the marital home, and eventually they broke up. They went back to court where the court ruled that they were to have equal time sharing with both of these children now, and that we would address child support in a separate hearing because there was already a final judgment dealing with child support with the older minor child. So a couple years after that, the former wife wound up filing a motion for child support saying, hey, my former spouse, he never paid any of this $800 a month that he was court ordered to pay. The former husband responded by saying, wait a minute, I did pay the $800, but once we reconciled and you moved back in, I paid for all the household expenses and everything else. So he used the argument and asserted the defense of laches, saying that mom should not be entitled to this. What the lower court did here is that they originally set an evidentiary hearing, but before anybody could even get to argue the defense of laches or anything of that nature, they solely sort of decided on their own. The case suggests that because the former wife never pursued this claim back when, she waived this child support claim that she may be entitled to. So then they dismissed it, which is what is appealed now. And what the appellate court said is, in this context, when you're dealing with child support, a parent can never waive the child's right to support. And in order to determine whether the former husband's claim of laches even were to apply, you would have needed an evidentiary hearing, because it's possible that could have been barred. So because of those reasons, the appellate court reversed and remanded this court, where they said, we have to have an evidentiary hearing on this issue of support to see if these issues may even apply. And that takes us to equitable distribution.
We have the Briggs case as our case number 9, and another depletion case and valuation date. If you don't find waste, you can't charge the data filing value of an account. You have to charge whatever's left. Right up there with the loss of transcript. That's, the second most cited category of cases in the past 5 years, I would suggest. Our next income case, Kennedy, it's crossed out because I don't know what happened to it. It showed up in the Florida Law Weeklies, but it has not appeared on Westlaw yet. So I'm thinking something happened between Florida Law Weekly, and we will probably find out about that next month. But it was a interesting case in the 4th about someone not requesting the imputation of minimum wage, and you got to request it, but something's happening with that opinion, so we'll keep an eye on it. And we have as our first injunction case number 12, Garcia v. Sota, where the court initially granted a stalking injunction and found that incident between ex and new boyfriend, that 4 separate acts happened really at the same time. And the court came back and said, well, that's really just one continuous act. And even if it was not in separate acts, it would not have risen to the level of causing someone substantial emotional distress. It would have just been an annoyance. There is a interesting dissent by Justice Artow, who tries to carve out, the fact that there's an or in the statute, and it's either maliciously, repeatedly follows, harasses, or cyberstalks another person. Kind of out there on a limb. I don't agree with the dissent, but something to look at if you're interested.
So continuing on in injunctions, our next case is Alcon versus Collins. This is a first district case out of Okaloosa County. So this is an interesting case because the petitioner was a Florida resident and the respondent was a California resident. And they met on Facebook and they were platonic friends, and Florida petitioner went out to visit California respondent, and she stayed out there for 2 weeks looking for a job. There was a heavy focus on testimony that she was not involved in a romantic relationship with a respondent, and in fact was engaged to someone else during this process who testified at the injunction hearing for all that it was worth in its glory, which actually hurt the petitioner because what she was seeking in Florida was a domestic violence injunction for protection against the California respondent, who was a platonic Facebook friend who she went out and visited for 2 weeks. And she provided no substantial competent evidence that she intended to stay in California or uproot her life in Florida. And in fact, the testimony of her fiance, who was based in Florida, showing that basically she had every intent to come back to Florida, really didn't give her any standing to be seeking an injunction for protection for domestic violence, because under the statute 741.28, there needs to be either a family or household member as the person seeking the protection order. And simply put, Miss Collins, the Florida petitioner, just didn't meet that criteria. And in fact, there was a California action pending at the same time with California guy now as the petitioner seeking for protection against Florida lady. And there was testimony out there that conflicted with her testimony here in Florida. Anyway, super exciting and long-winded read, but there's a very long discussion of her residence and where she was living and what she was doing and all of that. But at the root of all of this, a long distance platonic relationship, when you're not a family member and not a household member and realistically had no intent ever to be either of those things, you can't ask for protection through an injunction for protection against domestic violence. So this was completely reversed. And that is our injunction case of this month.
That takes us to modification. There's only one case this month for modification. Daniello v. Settle out of the 4th District in Palm Beach County. Here, the parties entered into an agreed final judgment. The mother had moved less than 12 months later from the agreed final judgment to modify the time. And her main argument for her reasoning to argue the time was because she has represented that she is now sober, which is a material change in her circumstance, and she requested more time sharing with the parties' children. However, and what the trial court had done is they said, yes, we agree this is a material change. We think it's great. You've maintained sobriety. This is in the best interest for the children. You can maintain stable residence now. And the trial court granted her a petition for modification. The former husband appealed to the court by saying that the court erred by finding there is a big difference between a substantial material and unanticipated change that isn't known at the time of an agreement or decision versus mom's simple life improvement. which should not qualify as a substantial change. And the father argued that here, this is just a mom who had overcome an alcohol problem. She is now getting her life together, and she started to become sober 2 weeks after this agreed final judgment was entered. So what the appellate court said is we agree with the father that this is just a life improvement of the mother, and she didn't meet that threshold. So therefore, and also they made a note that her becoming potentially sober is not reasonably contemplated at the time of the judgment. So for that reason, this is reversed. And they also said that this doesn't prevent the mom from filing another modification to seek, another legal available reason why something should have happened. But you cannot use her sobriety as a substantial material and unanticipated change of circumstance. That takes us to case number 15, which starts parenting. There's 4 cases for that this month. The first one is Levy v. Donnerfeld out of the 3rd District. And what this case basically teaches us is that when you go to trial or hearings, be very careful and sort of reread what parties have pled for, because here the mother appealed a final judgment of dissolution of marriage, which awarded the father majority time sharing and sole decision-making authority as to the medical needs. And what the appellate court said is that, unfortunately, the record supports the proposition that this decision-making was tried by consent. So therefore, the court was allowed to make sole decision-making as to the child's medical needs, and it was supported by competent substantial evidence. So always be sure, and if it's not pled for, make sure we're making those proper objections for our clients.
And that takes us to the Hernandez case, which is kind of a relocation case. But the parent wasn't relocating. The parent was in one place, the other parent was in their other residence, and the dad filed a petition to relocate the primary residence of the minor child from mom's house to dad's house. In the alternative, he also pled for a modification. The appellate court said, well, this isn't really a relocation because the parent's not moving. You're really just trying to modify the underlying agreement. So relocation statute does not apply if a parent is not actually moving. The court did modify some of the time sharing. In fact, he modified some of the summertime sharing, which wasn't even requested. That part was reversed just because it went beyond the scope of the pleadings.
Yep, we're going to continue on in parenting, and the next case is TA versus AS. This is a 2nd District parenting case. There was a final judgment of paternity entered, and dad was determined to be the biological father of this minor child. And among other things, the court set up a time sharing schedule for dad with the child. And this time sharing schedule contained a step-up parenting plan that was based on prospective events that were benchmarks that the father was supposed to complete or meet along the way over the course of months and years, and his time with the child stepped up accordingly when he met these benchmarks and these prospective events. And the perspective-based parenting plan with these steps along the way that did not require any court intervention along that process was an error based upon the 2nd District's determination in this case. And they actually reversed on the time sharing part because this perspective-based parenting plan that doesn't require any judicial intervention along the way is improper per the 2nd District.
And that takes us to case 18, which is the Seath case. We talked about it earlier in the program. And this part talks about when someone relocates 45 miles, we have the Halbert decision that says that alone does not support a substantial change of circumstances. In Seath, they granted the modification, and they distinguished the Halbert case, which is out of the 2nd, by the way, in a couple ways. First, in Halbert, the parent was seeking a change of custody, not just a change of the time sharing plan. Although the majority recognized that the father's relocation would result in longer drives to and from school, the majority did not consider the change as so substantial as to change the custody arrangement. So unlike Halbert, in this particular case, the court did not change the custody arrangement. The mom remained the majority person with time sharing. The father did asked to change some of the time sharing, which basically just gave him 6 additional overnights over what he had. So under the Seath matter, if you're not seeking a significant modification of custody, but just a improvement in time sharing, I guess you can do that if the only reason is someone moved 45 miles away and things are different. But Halbert still applies, if you're trying to change custody, that relocation alone won't cut the cheese. So you have that in your arsenal now.
Case number 19, Fletcher v. McCulloch out of the 4th DCA. This is a paternity action where the father appealed a report and recommendations based on in a paternity action. Here, he filed an exceptions within the 10-day rule by saying that the child support calculations didn't match the oral pronouncements of what the magistrate said at the hearing. And under the rule, you have 10 days from when a magistrate issues the report. He properly filed those exceptions. He also, 2 days later, filed an amended exceptions to the magistrate report. But at that time, the magistrate, the judge, they just denied his exceptions hearing and they entered an order. So his exceptions hearing wasn't even ruled upon. So he appealed that, and the appellate court said, we agree, this is reversed. There was no basis for denying his exceptions. They just unilaterally adopted the order, and he properly filed his exceptions within the 10-day time frame. So for that reason, the order was reversed and remanded until they can hold a hearing on his exceptions to determine whether that was valid. Case number 20.
And 2 more cases to go under procedure. 20 is the Samud v. Marwan case out of 3rd DCA. Dealt with cert relief on a discovery matter. We've seen a lot of those this year. In this case, the court ordered him to turn over his passport in a enforcement proceeding, because you can tell where someone's traveled and maybe how much they're spending, or if they're traveling extravagantly. And the court awarded it, and the petitioner filed a writ of certiorari. And the appellate court reminded us that to be entitled to that type of relief, you must demonstrate a departure from the essential requirements of law resulting in irreparable harm that cannot be corrected on post-judgment appeal. The departure from the essential requirements of the law is more than just legal error. It requires a showing of a violation of a clearly established principle of law resulting in a miscarriage of justice. Here, even if the appellate court agreed that the discovery was irrelevant, this was not, as they put it, cat out of the bag material that would have caused injury outside the context of the litigation. So absent anything else, the production of possibly irrelevant information fails to satisfy those conditions for cert relief. Case 21, Network Com of Northwest Florida versus the Department of Revenue. And we all know that individuals, non-parties, have a right of privacy from their financial records being disclosed, with some limited exceptions. In this case, we find that corporations don't enjoy that right to privilege or to privacy, and especially when one of the parties has check writing capabilities. So in this case, the non-party network communications of Northwest Florida objected to, based on constitutional grounds. And our first district said, you're a business, not an individual. Therefore, these protections don't apply to you. That is case number 21. That takes us to the end of the March cases. Thank you, Caryn and Gina, for joining me. Great job. Now it's we haven't done one of these this year. We've been so busy doing board cert tips. We have a real treat. One of my heroes and mentors we get to interview. And this month we have a nice living legacy interview with Roberta Bobbie Stanley.
Welcome to Stephen's Sandbox, a segment where a Florida family law legend steps into the sandbox with Eddie or Caryn Stevens to discuss ethics, professionalism, their career, and staying sane in such a high conflict industry. Are you ready? It's time to step into Stephen's Sandbox.
And with me this afternoon is our living legend, family law, Roberta Bobbie Stanley, who is a partner at Brinkley Morgan and has been practicing family law here in Florida for 35 years. Bobbie, how are you doing today?
I'm doing great. How are you?
I am awesome, and I am just so honored to get a chance to chat with you and talk to you about some fun things like professionalism. And we have a whole bunch of subscribers that I think look up to you as one of the preeminent lawyers, family lawyers in Florida right now. So thank you for your time today.
Oh, you're welcome. It's a pleasure to be here with you.
So you've been practicing 35 years in Florida, and I noticed that you became board certified pretty quickly after you passed the bar exam, about 9 years after. Can you tell me what made you do that and why you think that's important?
It's a funny story. I mean, I didn't have a lot of these people have such aspirations. I was sort of kind of person that just kind of put my head down and went to work. And it was really my husband who we had been going to the American Academy of Matrimonial Lawyers seminar. And he's the one that really encouraged me that I needed to go get board certified because I was still doing a good amount of commercial work. I started as a commercial litigator. In fact, I didn't even take family law in law school, as a matter of fact. I didn't. And but when that time came, he said, you need to sit and take the cert exam. And I did and passed.
And how do you think that's impacted your career? And would you recommend this for all of our listeners that are thinking about taking the test next year now?
Yes, I think the most important thing about the test, the most important thing about the test is that it forces you to really get into the weeds and learn family law. You have to memorize, you have to go through the UCCJA and some of the general concepts that you have. You really have to learn the details of it. And I think that is a tremendous impact on your practice as you go forward, because a lot of the times you don't even know what you're missing because you don't know that there's something in there that you haven't covered. So I think it helps raise your skill level, help raise your awareness. Even if you can't solve the problem, you can at least know, oh, there's something in there. There's a problem. I better check it out. I better do some research, or I better talk to a tax lawyer.
Whenever we have a legend amongst us, we love to ask practice tips. I'm sure you have some unique insight, some Bobbie-isms that you could share. And I was wondering what tips you had for us.
Yeah, I think one of them is, one of the things that I think that family lawyers do is they do not, at the initial consultation, give realistic expectations to their clients. And I think this is one of the most unfortunate things for the clients, because when you feed them with unrealistic expectations, it sometimes makes the case way more expensive, way more difficult to settle. Most of us who do this have a really good range or an idea of where the case is going to resolve. Now, you might not in a prenup agreement or a big business valuation issue if it's one where you are hundreds of millions or $50 million apart. That's different. But in most of the cases, you can give them some realistic expectation of what they're looking at. And if they come in with realistic expectations of what time it's going to take, what they think the result is, what the process is, I think it's better for the family lawyer and way better for the client.
Certainly a lot better at the end of the case when you get either a mediated or a judicial result.
I've had so many clients tell me that they remember what I said at my initial consultation and how happy they are to know that that's basically what happened in the case.
Awesome guidance. Anything else you want to share that could help us out?
Yeah, I think also that a lot of people do not, we have so much email now, and it isn't the same as picking up the phone and talking to your client or seeing your client. And I think a lot of this thing that you just email and text people and you think that's enough to keep that bond, because as you go through this process, these people think that they're the most important people in the world to you and that your case is their only one. And they should, because it's a very difficult time in their life, probably one of their most difficult times. But I think there is now this trend towards, oh, I emailed you, I sent you a text, didn't I check? Well, that's not always what they need. They need some hand holding, they need some personal interaction, and they need to have somebody that they actually feel is listening to them. And when you do that, you keep control of the client. And it also helps you, again, able to resolve the case and prevent you from going to trial, because the client then has a trust in what you say and will listen to your advice.
Even more difficult in the current situation where everything seems to be Zoom, and we're slowly matriculating back to live court. And I had a trial the other day in court, and it just felt so good to be back in the four walls of a courtroom as opposed to doing Zoom. But as attorneys, we adjust and we keep going.
But Zoom is still better than just emails and text. So at least at Zoom, they can see you. You can have some interaction like you and I are having. If you're just on the phone talking or you're just texting, it's just the Zoom I thought was better than the alternative. We wish we could have been together for 2 years.
I don't even let my clients text me. I need my mental health, so I protect my cell phone like it's my only link to sanity these days. Now that we're going back into the courtrooms, I see a lot of young attorneys. Some of them get it right off the bat. Some of them seem to be either too aggressive, or a lot of attorneys I see, sometimes take the persona of their client. Any words of advice for handling yourself in the courtroom with grace?
Yeah, I think that what happens is people tend to personalize if you're on another side and you disagree with their opinions. And the wonderful thing about law is we don't have to agree with each other. And I can have many times when a judge looked at me and I've made my whole argument and the judge just looked at me and says, I understand, but Ms. Stanley, I just don't quite agree. I don't read the statute that way. But that doesn't mean it's personal. And so I think the problem that you have in the courtroom is, I have some lawyers, and I've found this over the years, that they have to dislike you. If you get into a really contentious case, they want to make it personal. I was just saying that I think that if they don't personalize it, and if you keep it as that people are going to have disagreements, you can be hotly arguing and furiously believe your position and your argument in court, but that doesn't mean that it's a personal thing or a personal attack, and you should be able to congratulate each other and shake each other's hands when you're done.
Now, recently, we had a case, and our client certainly didn't see eye to eye, but I always enjoyed the interactions between our offices and the professionalism that you showed. And I don't see why that just can't be the way it is.
Yeah, and sometimes they because the other thing is another thing, picking up the phone. It's interesting. You'll say a lot of things in an email that you won't say when you're talking or looking at somebody. So that's the other thing. I would tell them, please don't do that, and read your emails, make yourself write it and then delete it.
And these emails are permanent too.
Right.
Once you hit send, there's no return. Any tricks of the trade if you're in front of a judge and you want to be persuasive, and what are some Bobbie tips you would have?
Well, one of the things that I do in all of my cases, I like to make sure I tell a story. And I think the number one thing that all lawyers that I've lived by is preparation. I don't think there is a substitute for preparation. And if you think you can go in, remember I had a young lawyer say to me, I don't write out any questions. I have it all right here. Yeah, well, he lost the case. because it wasn't all right there. And so I say to all of them that when you go to a courtroom, the judges know when you're prepared and when you're not. They know immediately. They know if they've got a memorandum of law. They know if you've sent them the cases. They know if you know what you're doing. And so for me, the most persuasive way and the best thing for your reputation, if you're trying to grow as a young lawyer, is to be a reliable source of research and cases. And the judges know that they can rely on you, and you're going to tell them the good and the bad, and that you're totally prepared and you are prepared to present your case in front of the judge. And I think if you do that, you will definitely enhance your career.
And we have kind of something fun in common. We both did something for the Lord's Place where we, this is one of my favorite Bobbie stories. We scaled down the Cuomo building. I think I was the first one in the day and you were the last one with your sister.
Correct.
Fortunately for me, the sun was out, but when you went down it was pouring. So I'm really good friends with your sister because we went through a leadership program together, Leadership Palm Beach County. And for those of you that don't know, Roberta's sister is the CEO of the Lord's Place, which is the biggest charitable organization in Palm Beach County, stamping out food insecurity and hunger and helping homelessness. And Roberta, I know you are a big part of your sister's efforts.
And we do sleep. We do sleep out every year. And I have I have another sister, and so we call the sisters. And we've worked on that and raised a lot of money throughout the years.
Well, thank you so much for your time today and sharing your wisdom. Any last little tidbits you might want to share with our listeners?
Yes, read your emails and make sure you respond in a timely way. I think what the most frustrating thing is, I don't know how some lawyers do it, but some lawyers don't read all their emails anymore. I know there are a lot. I know they come in so fast, but just as a thing, read your emails. Even if you respond a few days later, please respond.
I think a 24-hour rule is a good rule to not get you in trouble.
Yeah, get you in trouble.
Well, Roberta, thank you so much for your time and sharing your tips with us today. And we wish you nothing but success. And I'm so envious of the team of lawyers you've built at Brinkley Morgan. I think they're all, the family lawyers, they were all superstars, and I love working with them all. So you've done a great job cultivating that. And I just can't say enough nice things about you.
All right. Well, it's been a pleasure being here with everyone. And I just love being a family lawyer.
I think it shows if you do, and it shows with you, Bobbie. So thank you so much for your time.
All right, see you. Bye-bye.
Thank you for joining us for this month's edition of Stephen Squibb's Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.